years, much has been said about the congestion in the prisons, yet the ever-growing population of people awaiting trial continues persistently. In the last few days of President Jonathan's administration, the Administration of Criminal Justice Act was passed. Barrister Malachy Ugwumadu tells us a little bit about some of the innovations of this act.
At the heart of it is the issue of awaiting trial persons, what we generally in the legal circle call ATPs. Now, these are persons who are remanded in prison facilities pending trial. A suspect is brought before the court. Clearly, a court, say magistrate court, without the jurisdiction to entertain that category of offense. The magistrate looks at it. But in order to avoid falling short of the constitutional requirement, decides to remand him or her in prison facilities pending the proper arraignment in courts that with jurisdictions. This is how Nigeria has progressively congested the prison facility. So at the heart of it, so studies have shown that this prison congestion, which is a very big challenge in the administration of criminal justice in Nigeria, leading to issues of jailbreaks and violent incursions, has to do with these prison congestions.
Well, really, who is to blame? The police, the lawyers, the judges, or is it the law itself?
It cannot be situated within one sector of the criminal justice delivery system. It's a chain. The police effects arrests, investigates and effects arrests. He takes his file to the Ministry of Justice, precisely at the office of the DPP. The office of the DPP under the Ministry of Justice evaluates the body of evidence that he or her has in relation to the offense, advises whether to go on or to withdraw. If it's to go on, the matter is taken to a court. So you have moved from police to justice, the Ministry of Justice, to court. Now the court adjudicates over the matter. Upon conviction and sentencing, which are different things, the suspect, the accused person this time, is taken to where? Prison facilities. Even before that point, if the court, like I did emphasize earlier, finds that it has no jurisdiction, it reverts to the prison facilities. Upon the conviction of these persons, they are taken straight from court to the prison facilities. So you cannot pinpoint one particular organ or sector of the entire chain in the administration of criminal justice in Nigeria. However, what we have observed in the course of our research and activities as right groups is to clearly show that most of those cases, most of the sources of this congestion arise from the shoddy, inappropriate, inadequate activities of the police officers. Now, please, it is not only police officers. There are other agencies of government, law enforcement agencies of government that has arresting power, both arresting and prosecutorial powers. The NDLEA is both an arresting and prosecutorial agency. It has power to arrest and prosecute. EFCC has, ICPC has, Department of State Security has, even the customs, and so on and so forth. Now, when they finish with arrest, the next challenge is where do they keep these suspects? And all of these persons arrested by these various agencies, find their way in one prison facility or the other. The problem is that, and that complaint has been on, is that whereas it is easy to arrest, the challenge of trials, speedy trial at that, leading to either conviction or acquittal and discharge, is not as fast as the arresting, you can't compare with the speed with which they arrest.
Several people have proffered solution to this prison congestion, one of which is a strict implementation of the Administration of Criminal Justice Act, just recently passed in 2015, just about the time President Jonathan was leaving office. Now, this is a very new act. Can you tell us about it?
Now, this is a very important question. Yes, it is new. Indeed, you get to some courts and you are taken aback that people are still relying on the old legal regime. Now, if properly implemented, as a matter of fact, if we can go 60%, the issues of prison congestion will be drastically reduced.
What are the new innovations in this act?
Under the act, both the Inspector General of Police and the Controller General of Prisons are obligated to send periodic reports of the records of persons who are in police custodies across the country to the Attorney General of the Federation. It is not for just it is not just for the fun of it. It is to immediately give the Office of the Attorney General of Police an overview of the status of persons who are in prison facilities. Those whose prosecutions are going on, those in respect of which were arrested with or without warrant, those whose offenses are so negligible too as to activate their rights. I'm talking of the rights of the Attorney General and the right of the Attorney General of respective states under the Act to, visit these prisons and effect their release. Under the Act, police heads of agencies that has arresting and prosecutorial powers, like I mentioned in the past, NDLA, EFCC, are also obligated to make similar reports, just so that it is not only focused at arrest and detention that come and emanate from police stations. All of these other agencies also have that responsibility. Under the Act, you have a central recording registry into which all arrests across the country are centrally collated. These are ways by which a data bank or base will be built along the line of inmates of prisons. And the statistics are taken accurately to be able to monitor the incidence of either unlawful or unnecessary arrests or arrests, cases of arrest that has consistently bloated the number of inmates. Now, the essence of this is also to activate the right and power of the magistrate during her periodic visitation to prisons to be able to effect these releases that are necessary. Now, it has become very interesting to note that the Act has also empowered these supervisory authorities, magistrates, chief magistrates, attorney generals of the Federation, attorney generals of the states. There is a supervening authority on the part of this person I've mentioned to prevail over them and effect those releases.
71% of people in correctional centers have not been tried, which means that a good number of these people may not have any business being locked up in the first place. And if nothing is done and fast, innocent lives may forever be wasted. And that will do it for us on the program today. Thank you for being a part of it. Remember to send in your Nigerian police experience to the address on your screen. We'll have to talk about it next week. I'm Victoria Ido. Bye for now.